Case number 21, CR008, State of Ohio versus Melody Schrader. Here on behalf of the state's Assistant Prosecutor Adam King. Here on behalf of Defendant's Attorney Danielle Witt. You are Melody Schrader?
Yes, sir.
Okay. Thank you. All right, Ms. Schrader is charged with one count of aggravated possession of fentanyl related compound of fourth-degree felony. This matter set for status conference after her hearing earlier this week. And I have been presented to Ms. Schrader with a plea guilty form, which indicates you're going to withdraw your guilty plea, plead guilty. And on page 3, there are signature lines, and there's a sentence below the first full paragraph there that says, I enter this plea voluntarily. There's a signature there, looks like Melody Schrader. Is that your signature?
Yes, sir.
Did you just sign this here this afternoon?
Yes, sir.
And did you go over with Ms. Witt before you signed it?
Yes, sir.
And did she read it, explain it to you?
Yes, sir.
And is this something you've been discussing with her and considering before you came here today?
Yeah. Yes, sir.
Okay. Got enough time to fully consider this matter before making this decision?
Yes, sir.
All right, and are you entering this agreement voluntarily?
Yes, sir.
Now, the agreement states you're going to withdraw your not guilty plea, plead guilty. This is on page 1. To aggravated possession of the fentanyl-related compound under 2925.11 Revised Code 4th-degree felony. Further states that you understand that if convicted, the maximum potential jail term is 18 months, or a minimum of 6 if one's imposed. There's a fine available of up to $5,000. A possible life suspension of 6 months to 5 years. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you on probation, community control, parole, or post-release control for a felony?
No, sir.
Jurisdiction?
No, sir.
Now, under the law, Ms. Schrader, if you should be sentenced to prison, if convicted of this offense, once you complete the prison term imposed by the court, the law provides that the adult parole authority could, as part of the sentence, choose to put you under what's called post-release control supervision for a period of up to 3 years, meaning that you'd be supervised under the terms set by the parole authority by a parole officer. Because the court has no involvement with that. Now, that is not mandatory, it's optional, so they make the decision whether to do that or not. If they should do that, then during the time that you could be supervised, which would be, again, up to 3 years, if they determined that you had failed to comply, then they could return you to prison even though you served the entire term set by the court for an additional period of up to half of your prison term for one or more violations. But if your violation is a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you in this case to an additional period of 1 year, or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Right now, under the law, I'm not required to sentence you to prison for this type of offense. I can impose what's called community control sanctions, which means instead of going to prison, you'd be put under the supervision of a probation officer under terms set by the court. We call that community control. Most people think of it as probation. Now, and that could be for up to 5 years, and the court, meaning me, would set the conditions. Now, if the probation department felt that you were not compliant, then they would file a written notice of that with the court, and you would be served a copy, and you would be entitled to have a hearing and be represented by an attorney. Then if the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and sentence you to prison for 18 months and fine you $5,000 then. Do you understand that?
Yes, sir.
All right, now the charge alleges, Ms. Schrader, that on or about July 15, 2020 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit fentanyl-related compound in an amount equal to or exceeding 1 gram but less than 5 grams. Violation of Section 2925.11 of the Ohio Revised Code. So that's a 4th-degree felony with the penalty that I just mentioned to you a minute ago. Now, Ms. Schrader, do you understand what it is you've been charged with, what the state has accused you of having done, when, where, and how they allege that you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with her advice and confidence in this matter?
Yes, sir.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Right now, a little over halfway down on page 2, there are 2 lines that are typed in bold and underlined. There's 2 additional lines, but those have been stricken out. And the lines say, or it reads, the part that's not stricken out reads, defendant shall enter a plea of guilty to the indictment, state and defense jointly recommend community control, and that defendant be referred into drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Right now, under the law, Mr. Schrader, the matter sentence is up to the judge. So even if the parties agree on what the sentence ought to be, which is the case here, I'm not bound by that. And so once I hear all the information, if I decide that's not the correct sentence, I could sentence you to a prison term, or I could give you straight community control or other types of conditions that I think are appropriate. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state agency for any kind of an occupation or profession?
No, sir.
You have rights you have to understand before I can accept a guilty plea from you. First, you have a right to have an attorney. This witness appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you wish her to provide. So if you decide you don't want to plead guilty, you'll be defended by your attorney, and including having a trial if that's what you want. You understand that?
Yes, sir.
Okay, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens from this county, summoned for jury duty on your trial date. After they were selected, the evidence would be presented, and then they'd be instructed about the law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means give up, your right to have a jury trial. Then you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that witnesses against you have to come in and testify in front of you in this courtroom, and anyone else is here. And then after the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So what that means is that the witnesses against you have to come in, what that means is that if you have witnesses you're not certain are going to come in to testify, then the court will issue a court order, which is a subpoena at your request, and that would force those people to come to court to testify, even though they didn't want to be here, which is the same way the state's witnesses are forced to come into court to testify. Do you understand that?
Yes, sir.
Right, under the Constitution, Ms. Schrader, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can make you testify. The prosecutor can't, the judge can't. You make that decision. And if you make that decision, then not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even talk about it, except in one situation. That is, if there is a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you are guilty. In fact, at trial, you're not even required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the state of Ohio is required to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and that plea exercised all the rights I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admit that they're a crime and that you're the one who committed that crime. And that plea waives, gives up all the rights that I've just described for you today, except your right to have counsel, which you always have no matter what you plead. But with that exception, your plea of guilty waives, gives up your right to have a jury or court trial, waives, gives up your right to confront witnesses against you and to cross-examine through your attorney, waives, gives up your right to use the power of the court to compel or force witnesses being in court to testify for you, just like the state. Waives, gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court if I think that's the thing to do. And finally, It waives, gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I sentence you to the maximum sentence, or in other circumstances, you could file an appeal, but it would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, sir.
And are you a U.S. citizen, Ms. Schrader?
Yes.
Okay. Now, do you have any questions about the charge of possible penalties?
No, sir.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
And I don't know how much you know about drug court. You haven't applied for it, you haven't been interviewed, have you?
No, sir.
All right. Well, the drug court is not something that the court forces people into. They have to request to be admitted into it because it's a more intensive program. The purpose of community control is basically to give people a chance to stay out of trouble and not go to prison. But it doesn't, staying off drugs is a component of that, but it's not the primary focus or the sole focus. Drug court focuses on sobriety and getting sober, staying sober, and then building upon that to improve your life and give you the tools necessary to succeed. It's tougher and it takes longer. Usually we're talking about a minimum of 18 months. Right now we're looking at more like 24 months for somebody to complete it, as opposed to generally community control is about 18 to 24 months. And the conditions are more intensive, there's much more drug testing, but there's a lot more services provided. And because it focuses on sobriety, then you're unlikely, if you stay sober, you're unlikely to get more trouble. But if the sole purpose of your goal in this case is to stay out of prison, then that's not the program for it. But Ms. Sturgill will screen you for that. She'll determine that you have to meet certain criteria. You have to be a resident of the county or live in adjoining county. You have to have a certain score on a risk assessment. But the final, just because you're referred there doesn't mean you will go into it, because in the final analysis you have to ask to be put in the program, and then I have to determine that you are eligible. So you understand that?
Yes, sir.
Okay. Now, do you have any questions about the constitutional rights I explained?
No, sir.
Do you understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
Well, if you have any questions first.
No, sir.
Okay, that's okay. There's a lot of people that do that. Do you have anything you'd like to speak with Ms. Wood about before we go any further?
No, sir.
And do you have any questions about anything I've explained to you?
No, sir.
All right, then, Ms. Schrader, is it your decision to go forward and enter a plea of guilty to the charge and the indictment pursuant to the terms of this plea agreement we've just gone over?
Yes, sir.
All right, then, as to the charge, if you, what does that say? It reads, in honor about July 15, 2020, Highland County, Ohio, we did knowingly obtain, possess, or use a Schedule II controlled substance to let a fentanyl-related compound an amount equal to or exceeding 1 gram but less than 5 grams, in violation of Section 2925.11 of the Revised Code, charge of aggravated possession of a fentanyl-related compound, and fourth-degree felony, granted possible prison term of 26 to 12 months, 6 to 18 months, and fine of $5,000 and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. The court finds on this date, the defendant provides of all her constitutional rights made a knowing, intelligent, voluntary waiver of sanction criminal 11. Pleas accepted, order 5. The defendant is found guilty of the charge as set forth in count 1 and 4 through 5. Court will order a pre-sentence investigation under the same bond, and that will include an assessment for substance use disorder treatment and or mental health. Defendant also is referred to drug court. And what I want you to do as soon as you get done here this afternoon is stop down at the probation office and ask to speak, make an appointment with Ms. Sturgill, who's the drug court coordinator. And then also you'll need to talk to Officer Bolton, make an appointment for you to see him, because he's going to prepare a pre-sentence report after interviewing you and administering the assessment tool and other information that he will put in that report for me to be able to use to review your case when I come to make a decision as your sentence. We will set your sentencing hearing for April, let's see, what date are we using? April 21st?
We use it 22nd.
22nd, yeah, April 22nd, thank you. at 1 p.m. And that will be in person. We're converting now, starting to do more in-person hearings, so all of the sentencing hearings are going to be done in person now. So the realtor will give you a sign notice and remind you that. And you are still at recovery council.
Yeah.
And
Yes, sir.
how much longer do you think you're going to be there if we get a transition?
I'm going home.
How long are you going to go home?
Yeah, I would say place to go now.
What is that?
It's in courthouse.
Okay. All right. Well, you'll be talking to Ms. Sturgill, and they'll talk with you about that. And that's one of the things that also the treatment team that will work with recovery council and others will also help you with in terms of the transition from residential back into the community and where they should be. Sometimes when home's okay, sometimes it's not. Maybe sometimes that's the only option. Sometimes there are better options. So just need to she'll talk to you about it because that's all part of what goes into drug. Okay, so I forget when your trial date was, but you don't have to be here today. 12th or 15th, I think it was. 12th. All right, so you don't have to be here for that day. Get your sign notice, be here on the 22nd, then go right down to probation.